This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Please allow me to present our final speakers, the Honorable Angela Bradstreet and the Honorable James McBride, who will be speaking on do's and don'ts in mediation and settlement conferences. First, the Honorable Angela Bradstreet joined ADR Services in April 2022 after almost 12 years as a judge on the San Francisco Superior Court. Judge Bradstreet spearheaded the court's highly successful judicial settlements program and has successfully settled and mediated hundreds of cases ranging from one of the largest ever wage and hour class actions to complex commercial, personal injury, premises and products liability, landlord-tenant, whistleblower, sexual harassment, and discrimination cases. During her final 2 years on the bench during COVID, her remarkable talent for settling cases resulted in a savings of more than 7 years in trial time for the court. In 2017, Judge Bradstreet was honored by the San Francisco Trial Lawyers as Judge of the Year. Prior to her appointment to the bench, she served as the California Labor Commissioner. Widely recognized as a pioneer for the advancement of women and LGBTQ equality, Judge Bradstreet is a former president of the Bar Association of San Francisco, California Women Lawyers, and the Queens Bench Bar Association, and has received numerous awards, including the American Bar Association's Margaret Brent Women Lawyers of Achievement Award. And finally, the Honorable James McBride has served over 2 decades on the San Francisco bench as presiding judge, civil trial judge, and a member of the appellate division. He is recognized in the legal community as being well prepared, a master of difficult and complex jury trials, and is equally well regarded for his talent in bringing forth settlement in even the most demanding of cases. Judge McBride draws upon a lifetime of diverse experience and expertise. Born and raised in San Francisco during a time of great ethnic, economic, and cultural transformation, attending UC Berkeley as a student, as students led the change in the nation's perspective of society and politics, and serving the community as a police officer for the San Francisco Police Department. Now available to serve as a mediator, arbitrator, referee, and private judge, Judge McBride continues to serve his beloved community by helping parties resolve their disputes outside of the court system. Judge Bradstreet and Judge McBride, the floor is yours.
Thank you. So we are quite cognizant of our position in this presentation. I was shocked this morning to learn that it started at 8:30 in the morning. A bit uncivilized, but those of you who have to get your MCLE credit need to do what you have to do. Hopefully you've been through substance abuse. Oh, they don't call it that anymore, but presumably your urge to embark on the cocktail hour can be forestalled by what I will predict will be an informative, if not thoroughly comprehensive presentation on how to approach a successful mediation. We'll at least make it entertaining. We're going to do a do's and don'ts list for starters. And for that, I have to give credit to Judge Bradstreet, who I think assembled most of it, and I threw a couple of pot shots in. It is a combination of rules that are derived from statute, case law, and our professional rules. In addition, there's a smattering of what we, as former judges, think you should be doing. We haven't categorized them individually in the categories, but I think you can tell by the end of the presentation what we think is a good idea and what the law thinks is a good idea. You can disagree with us, but you probably shouldn't disagree with the law and the ethics. Judge Bradstreet, you want to take over and give us some do's and don'ts?
Sure. And thank you, Jim. Thank you all for being here at 5 o'clock on happy hour. You have our total permission. I hope that you're having a drink. For those of you who are in dry January, we're doing you a huge favor by having this panel at 5 o'clock in the height of happy hour. And we'll try and make it as zippy as possible. So the first thing that we're going to discuss is pre-mediation. First of all, exchanging mediation briefs. That might sound pretty basic, but I'm finding, certainly in some employment cases particularly, that sometimes clients are reluctant to exchange briefs. I would say in the vast majority of cases, people are exchanging briefs, but sometimes there is a reticence to exchange. And all I can say to that is that please have your clients remember that they are not only trying to persuade the mediator, Jim or me, they are trying to persuade the other side. And so if you have got a bang up mediation brief, I strongly encourage both sides to exchange briefs a sufficient time ahead of the mediation. I don't know what you do, Jim. I ask for mediation briefs to be exchanged 7 days ahead of time, because that then gives time for, as soon as plaintiffs exchange their briefs with defense counsel can shoot it off to the carrier or to in-house counsel, whatever the case may be, so that in-house counsel and the carrier, if applicable, have the time, and often these briefs get sent around committees of people. So you're not just trying to persuade me, you're trying to persuade the other side. I don't know what your experience has been, Jim, with exchanging briefs, if you've run into any issues there.
Well, episodically, I encounter cases in which the two sides have not exchanged briefs in advance. And I hesitate to categorize, but it seems to be like a regional thing. For instance, a lawyer in Texas said, we never exchange mediation briefs. Okay, I'm not going to change that. Just this week, I ran into an attorney who said, well, I don't want to do it because it's going to give away my strategy. Well, this was pre-mediation or pre-filing mediation. There was no strategy. It was just a knee jerk on this lawyer's part to not do it. I spent about 10 seconds convincing him of the wisdom of telling the other side what the problems are about discovery so we could get going. I think what you just said is really important. Persuading me is one thing, but there are people who are going to spend a lot of money if this works, and they need to know why they're doing it. And a good, persuasive, candid brief from the other side is very important.
I had a PAGA case recently, and also a discrimination case, where there was a reluctance to exchange briefs. And one of the factors was that experts had not been disclosed, and the one side did not want to give the other side a notice of their expert's report, or even the idea that they might need an expert in a particular area. So I said, fine, just email me the expert's report, leave that out of the rest of your mediation brief, and then go and exchange everything else. So sometimes things can be redacted, but rarely, I very rarely, if ever, I can't think of a single case when it's benefited settlement by not exchanging briefs.
Well, and Judge Bradstreet, we'll get to it later, but there's two phases to the lead-in. First of all is the writing that goes to the other side. Then there's the private conversation ahead of time that I know we both insist on.
Right, and you're absolutely right. We will absolutely get to that. Just a brief comment about preparing your client sounds pretty obvious, and of course, everyone's aware of the duty of candor, not only to the court but to others, which would include mediators at a mediation under the rules of ethics. But more importantly, when you prepare your witnesses, it's one thing to prepare them. It's another thing for them to sound totally coached. And so we want them to come across as credible and not to exaggerate or distort their claims. I had a case recently where the plaintiff told me absolutely, unequivocally, categorically that she absolutely had never taken cocaine, ingested cocaine, and that she did not have an addiction, which did not contribute to her emotional distress following her very valid sexual harassment claim. But you know, that of course was very problematic with her credibility when medical records had been produced talking about her cocaine addiction. So things like that, be mindful of. Next slide, please. So in terms of what goes into a mediation statement, again, keeping in mind that you're trying to persuade not only me, but the client. And I'm going to be much more persuaded by, I mean, obviously your beautifully written, articulated words I will take very seriously, but far more persuasive is the actual evidence. In other words, in a personal injury case, for instance, I can't believe the number of mediation briefs I get where the video of the accident is not sent to me. So then I ask for it. I don't have the police report. I don't have deposition excerpts. In employment cases, I want to see the actual emails and the actual texts at issue. I don't care if there's 100 of them. I'll read all of them. But more importantly, you want the other side to see them. You want the other side, the in-house counsel or the carrier, to see the evidence. And it's not like you're hiding a smoking gun here. It's all being discovered in discovery. But sometimes I have found that attorneys' interpretations of what is said in a deposition may not, be 100% with when you actually read the actual deposition testimony. And it's far more persuasive for me when I can actually show the other side, okay, this is what your client said at his or her deposition. I'm not quoting from the other side. I'm quoting directly from their deposition. Jim, what about conflict situations here? Have you run across any issues relating to conflicts with mediations?
Well, I frequently, usually I have one mediation in my list of cases where one lawyer or firm will represent multiple plaintiffs. And I don't know that it interferes, but I frequently wonder how they, because the defendants usually don't say it's, $100 for Bobby and $200 for Sally and $300 for Jimmy. It's, hey, here's the money, they figure it out. And I have been called upon to mediate the following mediation among them. And I must say that I'm not real comfortable with that.
Yeah.
But that's up to the lawyers. And by the way, this part about preparing your client, the legislatures step in their own special way, and we'll get to it later, but you have to tell your client at the earliest possible point that you may be going to mediation. Gone are the days when you phoned up on Friday and said, show up at ADR Services on Monday, we're in mediation. This is an informed consent issue about a critical decision in the client's case. You probably all know about it, but we'll get to it.
So I think that segues into one of the most critical takeaways I think we have today is the importance of the pre-mediation call with the mediator ahead of time, a private call with the mediator ahead of time. I do mine on Zoom. I don't know about you, Jim, but where possible, I prefer to have Zoom so that I'm looking face-to-face at counsel.
I agree with you in principle, but I usually do a phone call, but I'm being persuaded to the Bradstreet school of in-your-face pre-mediation calls. And on the subject of conflicts, one of the biggest issues in these pre-mediation calls is when I talk to the defense side, always insurance, and say, look, reservation of rights, any issues? And, the insurance defense counsel has to walk that very, very tight line. And they say, well, yeah, no, there's some big coverage issues. I find it that most experienced insurance defense lawyers are very happy to have me recommend to their client that they get independent counsel. They're very happy for that because it takes the heat off them, and now the other lawyer can help out. It doesn't always happen. They're
Exactly.
very, but I always bring it up in my pre-mediation call.
Yes, especially when there's been a policy limits demand in that regard. Also on coverage issues that you can explore in pre-mediation, when there are some covered claims, when some claims are covered and other claims aren't covered, right?
Yeah.
Obviously, the duty to the duty of defense counsel is primarily, first and foremost, to the insured, and so that's a great time for us to talk about. Okay, so how we, in terms of emphasizing the covered claims versus the uncovered claims. All of those things are incredibly important in pre-mediation calls. I'm sorry.
And there's the big issue of sometimes the insured is going to be called upon to contribute. And that comes as a major shock to, I've heard it a million times. I paid premiums to this company for 20 years. They need to, come up with it. And there's an uncovered intentional act. I'm sorry.
Yeah.
That's where the third party lawyer comes in, and that's where the education process comes in during the pre-mediation call, particularly if you can get the client on. I've had that happen.
Right. And you learn the politics involved. Often, I find that attorneys are very forthright in trusting me with information. I had one very prominent attorney recently tell me, I've got a very difficult in-house counsel, and she's probably not going to be receptive to you talking about costs of defense and things like that. So that was really important information for me. And we ended up, settling the case. Other subjects to discuss are the decision makers. I want to make sure, Jim wants to make sure, we don't want the mediation falling apart if the right decision makers aren't there. Now, gone are the days where the carrier, where defense counsel can say, gee, the carrier's not available, the carrier's back in New York, because obviously now with Zoom, it's very hard to argue that. But it can be when there's towers of insurance, for example. All of these things can be discussed ahead of time so that you don't have all these glitches come up that turn out to be deal breakers at the mediation. So
I have been badly surprised in more than a few mediations when we get right to the end and one of the parties says, okay, well, but I have to phone my cousin in St. Louis. What? So I've learned in the pre-mediation call to say, is everybody who needs to sign off on this agreement, whether it's, actual legal sign off, or how many people come to a mediation and go, I got to phone my wife? We work it out. I try to work it out with the lawyer ahead of time. Look, have the spouse, have the brother, whatever, have them at least available.
Right. And we just got asked the question, Jim, to clarify, this is a private call. This is not a joint call. This is a private call with each side. And I may have, if the defendants are in conflict with one another, I may have a private call with counsel for each separate defendant if they're not united. So we're talking about a private call, and I cannot emphasize the importance of this call. And you should ask, counsel should ask the mediator, to have this call, because it's not a perfunctory thing, you know, and you just learn so much, and you can set up the whole strategy for the mediation with both sides. And I'm an evaluative mediator, so I tend to you know, point out what I perceive to be the strengths and weaknesses of the case ahead of time, which I've been told people find that helpful. All right, I think we need to go to the next slide. I'm being told we need to move along, but that was a very important slide. Okay, during the mediation, obviously, we're not going to spend much time on Zoom backgrounds. It's pretty obvious. You know, I had a mediation a couple of months ago when an attorney had Zoom set up in his bedroom, and I was looking at his bed the whole time. I mean, you know, pay attention to background. Pay attention to muting yourself. Prepare your clients about muting themselves. I had a mediation literally last 2 weeks ago when the carrier predicted, I heard the carrier predict that my mediation proposal was going to be 7.5 million. And actually, so I felt pretty good coming in with a mediator's proposal that was under the defense, what the defense thought and were willing to pay. But I wasn't meant to hear that. So when you're, you know, explain to them when you're leaving a breakout room, wait for the mediator to leave the breakout room before you talk. Litigation tactics during the mediation. There are some that can be helpful, others that are not helpful. You're trying to settle the case, obviously. So anything that destroys or tampers with the trying to do this with that goal in mind can be really damaging. I had a major personal injury case that I'm sure some of you on this call are familiar with, and it was towers of insurance and the whole thing, and multiple plaintiffs with multiple wrongful death claims. And the wrongful death claim for one of the plaintiffs, we made a lot of progress. We agreed to do a second day 2 days later. And on the night before the second day, an investigator was sent out by the defense to the son, asking the son about his relationship with his stepfather, and basically to try to show that his damages were really not that much because he had a close relationship with his stepfather. So having lost his natural father wasn't a big deal. I mean, I don't want to be crass about it, but that was, and it was just horrific. It got back to the wife. And we had a lot of damage control to deal with. I mean, I dealt with it, but it was challenging. On the other hand, some employment litigation tactics can be helpful during a mediation. If there hasn't been, you know, I've had it where defense counsel will say, or the carrier will say, why are they talking about bad faith? We haven't had a policy limits demand. Well, and then sure enough, a policy limits demand gets sent. That can be helpful. Jim, what's been your experience there with litigation tactics?
I've never had that kind of a black op conducted on a grieving plaintiff, but for the most part, litigation tactics of being overly aggressive, you know, I ameliorate that in the session. You know, let me rephrase that for you.
Yeah.
Is it okay if I put it this way? And, you know, there are a lot of people who come to mediation just because they're like two cats in a bag when they're together. They cannot see each other. And that can be either the lawyers or the parties or both. So I don't know that I'd call them litigation tactics as much as just efforts to aggravate things as opposed to ameliorate.
What about sharing the same definition of terms of art? Have you got any thoughts about that?
Wow, that's become a big issue recently for me, and I want to bring it up. I hope other people haven't had the same issue, but People throw around, well, let's do some brackets, or I love this one. That's my last, best, and final. So I had a case that had gone on for a long time, and one side was getting a little fed up. And they said, this is all we're ever going to pay. It's last, best, and final. I said, okay. So I left, and I came back and said, okay, well, the other side's signing off. And they go, well, wait, don't they have a counter? And I said, well, they didn't want to do a last, best, and final, and they took you at your word. Now, last, best, and final, I think, comes from the labor field, where you negotiate over a contract, and either the employer or the union says last, best, and final, and then you go on strike, right? That's but to me, last, best, and final means this is it, or you take it or leave it. Nice way to put it. You can say last, best, and final, but we will invite their last, best, and final. That's a good way to do it. Brackets. People do not seem to understand brackets. And I think rather than try and impose my definition, because it could be a half an hour discussion, just make sure when your mediator talks about brackets that you're on the same page with the mediator about what it means, what you're doing, and where you're headed. And then if the mediator doesn't look too sharp, say, can you make sure they're doing the same thing in the other room?
Well said. And yeah, brackets, we could have a whole seminar on brackets. I hesitate on brackets. In other words, I found that brackets can be useful when the parties are so entrenched and so miles apart. That's when they can be helpful. And you've said it well. Make sure everyone's on the same page in what we're talking about. All right, next slide, please. The mediation, this sort of brings us up to, how to close a mediation, how to get a settlement. And I know that reams have been written about this. I'm not an expert, but I can tell you about my experience and share my experience. Is it doesn't work to rush the process, to issue ultimatums, to come in and say, let's just cut to the bottom line, when you've been in mediation for about half an hour or an hour, and throw up your hands in despair. There's so much psychology and so many dynamics involved that the mediation dance, whatever you want to call it, and it varies from case to case in the personalities, but you still have to go through it, whatever it may be. And then you get to the whole issue of, closing it. And obviously a mediator has, that's on the mediator to close it and get it done. Because at the end of the day, everybody wants to settle the case. Otherwise, they wouldn't have agreed to a mediation. So whether it's a mediator's proposal, I don't know, Jim, how often you use mediators' proposals. I use them quite often, and I don't make them unless I think they have a very good chance of being accepted by both sides. But it's usually at the end of the day, and when I feel like both sides are kind of looking to me to close it. I don't know what your experience has been there.
It's the same. I think a mediator's proposal doesn't work unless both sides have, punched themselves out, to use a bad metaphor, and they're looking to you to say, look, we trust you enough to give a number that we think the other side will take or the other side will pay. But if one side doesn't feel committed to, they're going, well, I don't know, and then I don't think it'll work. This one bullet point here about have a draft settlement prepared. It is a rule and recommendation that is honored in the breach more frequently than in the observance. But I want to get back to it. It is so helpful to at least have your bullet points. A straight ahead settlement of a tort case probably doesn't need a lot of bullet points, right? But in any kind of business or, real estate case, there's almost always special things that somebody wants. Don't bring them up at 5 o'clock. Have them ready, and maybe you don't tell the other side, but front it to the mediator at some point early. The other thing is, we'll get to 664.6 and we'll get to the enforceability issues, but any draft settlement agreement, and I'd say any mediator's proposal, needs to have the part in that says this can be disclosed to be enforceable in court. It's a big deal.
Right. Okay, so Jim, going to the next slide, do you find that incompetence or ethical issues arise frequently?
No, but there's a lot of kind of loose talk. I don't know if it reflects loose thinking, but a lot of people say, oh, it's mediation privilege. It's mediation privilege. Like one can do anything they want in mediation. Obviously, anybody in this seminar knows you don't leave your ethics at the door, right? But the mediation privilege was established to protect basically face-to-face negotiations between parties, so that if they said one thing or another in the protection of a mediation and it failed, it wouldn't end up in a courtroom as evidence. And we have a really strong mediation privilege in California in the evidence code 703.5 and 1115 to 1129. And my basic bottom line is, don't be the one who pushes the legislature to start chipping away at it. There's a case called Cassell, which would be the next slide, which a guy, next slide, please. Mr. Cassell, he was down in Hollywood. I think he had a problem over a movie deal. Got to be 5 o'clock, 6 o'clock, 7 o'clock, finally knuckled under and settled. Signed. He wakes up the next day and says, wait a minute. And he sued his lawyers for basically browbeating him into a settlement he didn't like. The Supreme Court took a very, very strong position saying what happens in mediation is absolutely privileged and cannot be used, even if it's misconduct of a lawyer. This case was a classic disagreement about, a lawyer and a client on a settlement. But the absolute nature of the privilege shields attorneys from, ethical violations, misconduct, and everything else that could prejudice a lawyer. Was so strong that, next slide, please, that Justice Chin, now a member of ADR Services, issued a pretty strong concurrence saying, maybe we may basically need to consider this later on. The Law Review Commission took it up and said, other states have an exception for malpractice in a mediation. So you can't use what's said against the other side, but if your own lawyer committed malpractice, you can do it. The legislature, for reasons that were not disclosed to me, did not adopt that recommendation, but went to the current, it's been on the book since 2019, and I know you're all following it to the letter, but 1129 of the Evidence Code requires that at the earliest point, you get the client's full consent in writing. And there's a safe harbor form that is provided. Next slide. Next slide. That basically, no, the one before that. Anyway, this form is your safe harbor. If you use this, you're in good shape. This all has to do with the scope of representation and the allocation of authority between client and lawyer. And I think most of you instinctively recognize that important decisions about the course of the case, like settling, are a client's decision, and the details of how it's carried out is your work, but you keep in touch with the client about it. So just don't lose sight of that fact. What about written settlement agreements? Any
Yeah.
tips, and not just our own personal peccadillos?
Yeah, next slide, please. Okay, so yeah, we want them. I mean, so everyone, we for the benefit of your clients, you don't want to walk away from a mediation without a written settlement agreement. Obviously, with a class action or a PAGA claim, they have to be approved by the court. But you can get a memorandum of understanding that's executed by the parties. But ideally, it should be an enforceable agreement under CCP 664.6. And the Pappas case the Court of Appeal upheld Judge Wiss's ruling in San Francisco Superior Court, enforcing a settlement where there had been a short form agreement entered into at the mediation. And the parties in that short form agreement agreed to enter into, quote, a more comprehensive settlement agreement and mutual release, close quotes. And then what happened was the plaintiff tried to get more money for signing the confidentiality provision agreement in the later agreement. And the court said, absolutely not. No, that this was a binding agreement. It wasn't vague. It wasn't, and they enforced the agreement. The case does point out, though, that ideally it would be good to define your terms if you can. Just one word about confidentiality provisions, if I may. They can take on a whole life of their own. Seen it happen where there's so much, the defense asks for everything under the sun in confidentiality, trying to bar the plaintiff's counsel from basically practicing law, which you cannot do. And so, both sides have to be reasonable and realistic. And remember, in employment cases under CCP 1001, you cannot get confidentiality of the underlying facts in a harassment or a discrimination suit. That's now barred anyway. You can only get confidentiality of the amount of the settlement and probably the terms of the settlement. So, but don't leave without a binding agreement, and we'll discuss more. But basically, I always ask the defense counsel during the pre-mediation call, hey, can you please start preparing a short form agreement? And I don't want any surprises in it. Please don't throw in at the last minute some, you want a defamation language, no defamation language, you want this, you want that. That's all a surprise at the end that can then throw off the settlement. I said, please don't get any, let's get it out on the table now, early on in the mediation process as to what it is your client wants. And then we can start working on a reasonable, resolution of those terms.
So I think, the Pappas versus Chang case is worth spending a little time on, because my emphasis on this stuff and this mediation is keeping the privilege in shape and not having the case like the Cassell case that erodes the privilege. In Pappas versus Chang, it was a medical malpractice case in which it was structured, the settlement agreement was structured such that the offending defendant doctor did not have to reach the limit for reporting to the medical authorities. And the plaintiff wanted not only the money from a settlement for a botched surgery, but also to pursue the doctor's license. So in the mediation, the plaintiff didn't get exactly what the plaintiff wanted, which was an amount of money that would trigger a report. So the whole fight was subsequently about, well, you know, if I'm going to sign this confidentiality, now I want more money. And it's the kind of, there's I'm not encouraging you to read the case of the dissent. It's not that interesting. But there was certainly a judge on the Court of Appeal who took a real close look at what this settlement agreement accomplished in terms of public policy, which would be protecting, you know, arguably protecting a bad doctor. Ultimately, the trial court's decision to enforce the settlement was persuasive to the other two members of the panel. But it's one of those cases that I ran across, and it kind of opened my eyes to how the mediation privilege looks when it's, you know, it's out there being examined by the Court of Appeal. And what did Carol Corrigan say about the Court of Appeal? We go on the battlefield and kill the wounded and loot their bodies. Oh, well, at any rate.
All right, next slide, please. Jim, did you talk about the magic words? Because I think.
Well, yeah. How did this Pappas case even get into court? I mean, why are they talking about what happened in mediation? That's because the magic words were used. You have got to put something in your agreement that says that any disputes over this may be subsequently admitted in court. This agreement and what went on in mediation can be admitted in court. I will confess that I frequently get settlements made, you know, just a notation that's done, people sign without making that explicit. It has not come back to haunt me yet, but every time I go back to this presentation, I promise I'm going to do better every time. You have got to use the magic words. The leading case on that one's a fairly old one, Fair versus Bakhtiari. And, you know, there you are, a lawyer. You had a 2-year litigation that was absolutely bloodletting. You get the case settled, you forget the magic words. And the judge says, well, yeah, no, I read everything, but I can't take into account anything that came out of your mediation, including this agreement that doesn't contain the magic words.
Right.
You go back to rule 1.1 and start examining competence.
And by the way, ADR has a short form agreement with the magic words in for that will be a great starting point for anyone asking. Next slide, please. We've discussed CCP 664.6. We have about 9 minutes left, Jim. So the only thing I want to say about this slide is, and one of our audience has already asked me about this, which is anticipating this slide, as you all know, motions to enforce under 664.6 are not available after the case has been dismissed. So except if the parties have both requested and the court has ordered that jurisdiction be preserved. So what does that mean practically? You're in a private mediation with a private mediator. Either you have dismissal after all of the monies have been paid, the release has been signed, everything's been signed, and then you have dismissal after that, because then you're not going to have any issues of enforceability. Or if you have a long-term payment plan or something, and there's a reason why the dismissal has to be filed, then what you need to do is you submit a form of stipulation to the court, because of course we can't sign it any longer, that you submit it to the court, and the case has been settled and the parties have agreed to reserve jurisdiction, and then it is so ordered, judge of the superior court. So whatever jurisdiction you're in, you just say it is ordered. You have to get an order from the court. It's usually pro forma. It's by stipulation. It's a stipulation and proposed order reserving jurisdiction. Okay. There has been one question that I absolutely feel compelled that there will have been that we were remiss in not addressing. That's very important, Jim. What do you do in a mediation when the client relationship breaks down? In other words, when an attorney and their client go sideways, when the client goes sideways on the attorney, what do you do? How can the attorney salvage it? And my thought is, and I've done this many times, if you're on a Zoom mediation, the attorney can just, I always get their cell phone number. They just text me, or they can raise their hand and send me a chat and say, could we talk privately? And then I will talk. It's happened many times where I will talk privately with the attorney. If it's a live mediation, the attorney has walked down to my room and said, I need to talk to you, Judge. And then we can, the mediator should be your friend to help you with client control issues. And we can strategize. And often, the mediator is the bad guy that kind of comes in and tells the client as nicely as possible why the client needs to either, accept this settlement or whatever. Any thoughts there, Jim, on how you deal when an attorney has a breakdown of their relationship with the client?
Well, I do what you do, live, walk down to my office, or you run into each other walking down the hallway. And then, in a Zoom, take a text message and have a private phone call. But I can't say I've ever been asked to do anything other than say, hey, my client's really upset. I think we need to end today. I have not had a case where I had to go in and say, can we possibly save this relationship? I think it's probably just my luck.
I'm talking about when the client has expectations of settlement monies that may be unrealistic, and where the client is not listening to her own attorney.
Oh, well, that's at least 65% of my mediations.
There you go.
Yeah,
and having a private conversation with the attorney in terms of strategizing, and then talk, the attorney, it's not a weakness. All I'm saying is it's not a weakness for the attorney to share with me.
Oh,
hey,
no,
Judge,
no, I encourage,
Yeah.
You run the risk that the client may think that the client is being conspired against, but it is very important for a lawyer to be able to unburden to you, and then you and the lawyer decide how best to proceed with a client who, don't forget, is making a very important decision in their case.
True. Don't forget to DocuSign. Everyone needs to be adept at DocuSign in signing these 664.6 agreements. But fortunately, at ADR has these brilliant case managers who I just bring in. I don't know about you, Jim. And I say, Michaela, can you, get everyone's email address and shoot this thing off to everybody to DocuSign? And it's like, it's so easy. It's unbelievable.
Which brings up one of my favorite points as an aging American. Rule 1.1 is about competence, and it says that in addition to keeping abreast of the law, you are also to be aware and abreast of the benefits and risks associated with relevant technology. That's actually in the comment to 1.1. So you settled your case for $1 million, your client's happy, and somebody says, so we're going to DocuSign, and you go, we're going to what? You can't get the signature because you can't master the technology. Malpractice? I don't know. But more and more, electronic signature. I looked up how many different programs there are. There's at least 6 right at the top of any search. Different ways that you can get remote signatures. You can even do remote out-of-state notaries. I think it's something that everybody needs to be paying a little attention to.
Totally agree. Next slide, please. I think this is you, Jim.
So You just need to be aware that 664.6, there's an old case that said you had to have the client's signature or magic words in open court on the record. Now it's been expanded so that insurance reps can do it, an attorney can sign, but you have to have explicit authorization from your client. My advice is if you're going to sign on behalf of a client, get that authorization in writing, because if the client tells you in a mediation, go ahead and sign for you, then says, I never said that, you've got trouble because you can be disciplined for signing something that allows a settlement agreement to be enforced, because it's what? A very critical stage in the client's case.
Okay. Next.
That's what I just said.
Okay.
So can you be, somebody sent me this question early on. Can you be disciplined? Can you get in trouble for misconduct in mediation? Well, aside from like your reputation with the other side and with the mediator, I consider that to be trouble. Certain cases can be ordered to mediation. And there's one case, it's pretty old, but the city attorney or the sheriff, either one, was disciplined for not showing up at a court-ordered mediation. It wasn't much of a case, actually, but it turned into a published decision on showing up. One thing is that mediators cannot report to the court. So no matter how mad we are, we have to just stuff it. But the other side can report you for bad faith tactics in a mediation. For instance, not having your authority, not showing up on time, not being prepared.
Okay.
On this note, the local rules are important because, you know, certain jurisdictions, San Francisco not being one of them, but I think Los Angeles being one, say we can order you to mediation and you have to participate in good faith. I get a big chunk of my business from courts who say you have to go to mediation. And the lawyers go, we don't have a trial date. We haven't done expert discovery. We're halfway through discovery. What can we do? But they have to go to mediation. And the local rules would require them to participate in good faith.
Okay.
So I have some questions. Are we?
We're about out of time, I think. So yes. Yep. I've been responding to questions in writing. Go ahead, Jim.
My gosh, you're good. You multitask constantly. Did you answer the one about what makes the best mediator?
I did. I just did, but by all means, you chime in too.
Yeah, although I said you made the best mediator. So somebody says, somebody asked, is it okay to ask for more money?
What?
So somebody asked whether it was, ethical or proper to ask for more money for confidentiality. The answer is it's a burden on whoever is saddled with it. And as far as I know, it can also be the amount allocated to confidentiality can be taxable. So if you sign an agreement to settle your case for $100,000, and at the last minute they say, oh, we want confidentiality, should it ever come to pass, the taxing authorities get to say, well, we think 20,000 of that is for confidentiality. And you go, well, wait. All I did was agree at the end. It's not worth anything. The taxing authority is going to want their money.
Well, I would tell the defense if they threw it in at the last minute and my mediator's proposal had been accepted for $100,000 and then it was like, oh, and we want confidentiality, I would say to them, BS.
Yeah. Yeah. No, I mean, I am not real happy when we spent 8 hours.
No.
And everything's done. They say, oh, by the way, we need confidentiality, non-disparagement, and we want $5,000 liquidated damages.
Yeah, that's why you want to get it, as we said, get it all out early. early in the mediation process. Sometimes they're thinking outside the box. There are some terms, and we haven't really covered this, but sometimes there can be the settlement can be held up with personal reasons. I mean, especially in employment cases where there's a lot at stake for the plaintiff. The plaintiff feels incredibly disrespected for being fired. I had a case recently, very prominent law firms involved, where a plaintiff would work for 30 years at the same place, a very well-known place. And it really, for her, was about, she was fired, but she was laid off. And so I said, why on earth could the defense put in the settlement agreement that she was only laid off because of budgetary constraints and that her work performance had been outstanding the entire 30 years? And she cried. I mean, she cried and said that meant the world to her to get that done. So sometimes those kinds of terms, thinking outside the box, they're worth exploring. Okay, we're final takeaways. Next slide, please. Final takeaways. No, next slide. Final takeaways is everyone needs a drink, right, Jim?
Yes, of course, right. Well, thank you all for paying attention.
Yeah, thank you all very much for hanging in there with us.
Well, thank you, Judge Bradstreet and Judge McBride, and for the rest of the people who joined us and stuck with us for the entire day. As they say, well, that's it. When we close this webinar, you'll be directed to a survey regarding our programs today. We would greatly appreciate your feedback so that we can further improve our programs and offerings. And also, if you enjoyed today's programs, please visit our website at www.adrservices.com/CLE-program to find other MCLE presentations that we put on throughout the year. And so with that being said, we hope to see you again next year. Until next time, I hope everyone has a wonderful 2023. Have a great evening.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.